I'm Eric from Helps Law Firm for Seniors and Disabled Persons. Welcome to our YouTube live session today on March 3rd, 2026. My name's Eric, attorney for 48 years, the founder of Helps. Helps is a national law firm. We represent seniors and disabled persons who owe debt they can't afford to pay. Encourage you to ask questions in the chat section, and I'll attempt to answer them. Should be able to answer them. I'll start out today. I talked to someone yesterday, actually a Helps client in Minnesota. They enrolled back in 2024, 2 years ago. And they called yesterday and they'd gotten a notice for a trial. They were worried about it. They want to know if we needed to send anything. I explained to them, well, okay, when you first enrolled, you let us know about that lawsuit. And for whatever reason, the courts in Minnesota were really slow. And they finally set it for a hearing, looks like next month, 24 months later, okay, after they were first served. And the client had even forgot they had been served. I told them, explain to them how their income was protected, their Social Security was protected, and they didn't need to go to court. If they didn't want to defend themselves, if they owed the money, they didn't need to do anything. No one could do anything to them. Their money was going to be protected. Also explain to them how, their Social Security, when it gets deposited in their bank account, that bank account is protected from garnishment automatically by their bank under federal banking regulations up to twice the amount they get each month. And they had completely forgotten the fact that they had been served 2 years ago. And when I reminded them that, and they started to remember, oh, that's right. And I said, we already wrote a letter to the attorney who sued you, letting them know that your income was protected. And well, why are they going through with this, Mr. Olsen? And I explained, well, it's just automatic. It's on automatic. They just do it, okay? But they don't need you didn't need to worry. And so that's an important message we have for seniors that are listening to us, maybe for the first time. There we go. I need to mute my phone, otherwise it's going to be really distracting for me. Let me hear just a minute here. Sorry for the little bit of a delay here. There we go. They won't have any problems. So when is my bank clearance, my credit card account still appears on my account? Don't really understand the question. Maybe ask it in a different way. So if someone calls Helps, we explain to them how their income is protected, their Social Security is protected, their pension, disability, VA benefits, virtually all forms of retirement are protected from debt collectors. But maybe you owe money to the bank where you bank at. Are you going to have to change your bank account to a different bank? Not necessarily. I'll explain. There's a federal rule that tells banks that they cannot offset money out of your account if the only money that's going in there is Social Security. Now, technically, if there's other money going in there other than Social Security, they could offset money out of your account to pay a debt you owe the bank, although banks normally won't do that. Now, credit unions are different. Credit unions, when you sign up with a credit union bank account or when you make a loan with a credit union, whether you realize it or not, you signed a form that gave the credit union permission to take money out of your bank account if you owe the credit union money. Banks don't do that except for Truist Bank. So for that reason, if you have a bank that you're in love with and you want to stay there, even though you owe them money, like on a credit card, and you can still stay with the same bank. Now, the law's really clear if the only thing going in there is Social Security, but if there's other funds, they technically could offset it. But we don't see banks offsetting money out of their bank account to pay a debt as long as some Social Security is going into the account. Maybe that might answer your question. Okay. Um, a lot of times, clients call us. They get a default judgment and they're worried about it. So one of the one of the wonderful things about Helps is when you enroll in Helps, you're a client literally ongoing, which means if you ever have a question or concern, you can always pick up the phone and you call. Um, if we have 5 new clients, maybe 1 out of 5 is being sued, 3 or 4 out of the 5 are behind, um, being hassled. Maybe 1 out of 5 is completely current on everything. It doesn't matter where you are. But let's say you were being sued. Eventually, um, we're going to send a letter to the attorney when we get the lawsuit from you, letting him know that your income is protected. You're not going to do anything. We understand they're going to get a judgment. And remind the attorney of the protected nature of your bank account, although it doesn't matter because your bank account is protected by your bank without you having to do anything. But without you having to do anything. But we're going to call you on the phone and we're going to explain why you don't need to worry. Now, eventually, and it might be, a month, 2 months, 3 months, it might be 4 months, 5 months. It depends on the court. Eventually, you're going to get in the mail normally a notice of a default judgment, which simply means that the court has made a ruling that you owe the money. Okay. Now, that doesn't mean anything. The court isn't involved with trying to collect the money from you. That's up to the attorney. All the court has to do is determining if you owe the money or not. Okay. Now, if you don't put up a defense, then they win by default. Nothing wrong with that. If you owe the money, if you put up a defense, you're just going to get embarrassed. For that reason, a lot of seniors simply don't need to go to court. No one can collect from them. They're going to get a judgment. But normally that's just called a default judgment, where it happens automatically because you haven't put up a defense. Okay, you haven't filed an answer. Nothing's wrong with that. A default judgment is the same as a judgment on the merits. It's all the same. It's just an order saying that you owe the money. It doesn't say you have to pay it. They can't collect from you because your income's protected. So anyway, this person from Pennsylvania, they called us and they're worried they got this default judgment. They didn't know what it was. And I explained to them, well, you remember, 6 months or so ago, you got sued. Oh yeah. Okay. Well, finally they're getting around to this judgment. And the question the person had is, you know, does helps get a copy of the default judgment? Do we get served a copy? And normally not. Okay. Normally that would just go to you. See, we don't represent people in court. Helps doesn't do that. Um, when one of our clients gets sued, we notify the attorney who sued you. Um, we tell them we don't represent you, but we explain how your income is protected and you're not going to pay the debt. A lot of times, well, not a lot of times, sometimes that results in the attorney just dismissing the lawsuit. Not normally, but it does happen. But then eventually you're going to get a default judgment and that's going to go to you. The reason we're not involved is we're not representing you in court. So you're going to get that and you can send a copy to us if you want. You don't necessarily need to. But if you have any questions, just call us on the phone. We'll explain again why your income's protected, go over the importance of you having just your money in one account, and that's the account to which your Social Security goes. So, for example, if you get 2,000 in Social Security each month, 4,000 in the bank account is protected from garnishment, even if some of the money in the account came from another source. If a bank were to get a writ of garnishment after a judgment, then the bank, under the rule passed in 2012, they examine where the money came from in your account. And if it came from a federal source such as Social Security or VA benefit or federal retirement, they take what you get each month times 2 and they protect that amount. The bank doesn't have to pay attention to where the money actually came from that's actually in the account at the time of the garnishment. Okay. Um, my account on my bank statement still appears what I owe. Well, that would be typical. I, I if you have a bank statement, maybe your bank statement includes what you have in your checking account, and then maybe any debt that you have. Okay, I'm a little confused. And you would still owe the debt. Even though we send a cease and desist letter to a creditor or a debt collector, that doesn't wipe out the debt. You still technically owe the debt. You just don't have to pay it, and they can't do anything to collect from you. You're judgment proof. Camper asks, do banks and creditors look at what we spend money for, such as foolish spending? No, not that I know of. I mean, and I should know. Probably filed 30 or 40,000 bankruptcies before he started helps. Um, no, I don't. I don't see them making comments on what people buy. Okay, that's a good question though. Uh, they handle these collections in such a volume manner. Hundreds. They don't really have a whole lot of time to look at you and your situation, what you've done. They don't do that. Okay. So I talked to a lady from New Jersey yesterday. Her income is $1,200, and then she spends $900 on HOA. Now, what's HOA? That's homeowner association fees. Um, and she's living in a home that actually belongs to her sister, and her sister owns the home free and clear. But there's the $900 HOA fee for this community she lives in. Now, that's a lot of money each month. Each month. And her only income is $1,200. I asked her, well, how are you doing it? And she says, well, my son helps me out. I get some SNAP benefits. So some family members are giving her a little extra money, but she's just, three-fourths of her money or four-fifths is going to pay HOA fees. And she only had one debt. I think it was like $6,000, but she was really worried about it. Um, so I enrolled her in help. So she happened to talk to me, and I enrolled her. And I told her, I said, you're going to get our help for free. And she was befuddled. She said, I don't understand. And I said, well, I said, you've only got $300 left over after you pay for the HOA fees, and you got to deal with electricity, transportation, food, all these other things. I realize your family helps you out with a little bit, but they don't give you a whole lot. And she was crying when she was done. She just couldn't believe that she could get our help. And so, you know, that's what helps does. Maybe one out of 6 or 7 of our clients get our help for free. Those that pay a very minimal amount. We want to make it work for people. Okay. Um, she didn't have this particular person wasn't very computer savvy. She gave me a couple email addresses that were wrong because when we tried to enroll her, it came back as being a bad address. And so I said, what you need to do is have your family help you get the right email address so that we can send you confirmation that you're enrolled with helps. We enrolled her anyway, but she just didn't get our email confirming that she was a member yet because she was confused on her email address. So when you enroll in helps, we ask you some questions. We go over this with you. Some people call us 2, 3, 4, 5, 6 times before they decide to enroll. But when you enroll, we actually enroll you over the phone. We'll click a button and you'll get an email from us that says welcome to helps. And usually you get that within a few seconds, less than a minute normally. And it's a fairly long email that has our contact information, address, phone number, email address, gives instructions how to get us the creditors. And it gives some basic information. Um, so when you enroll, it helps. It's done literally over the phone, and it can be done immediately. So that means when we hang up after you're enrolled, if a creditor were to call you when we hang up after you enroll, you were going to talk, and you happen to talk to that creditor, you tell them you were represented by Helps, you give them our name and number, and then if they were to call us to verify that you're our client, you will be in our system as being our client. Okay, that's how we work. Person contacts us from California. I have debt, and some of the debt isn't mine. Someone used my identity when they stole my purse. One of my ex-husband used my name and social security number for his bills. So this person got a double whammy. They had someone stole her purse, used her credit, and ex-husband used her credit. So what is she going to do? Well, I'm assuming that this is a senior and that she's on social security or a pension. I mean, she could contest the debt and try to contest with the creditor saying that, the debts were fraudulently incurred. They weren't my debt. She could do that. Okay. That can get kind of complicated. We don't help people do that, but person could do that if they want. But you don't necessarily have to. That could be a headache and you may not be successful in doing it. You may have a problem. If you did nothing, it really doesn't matter because your social security is protected. No one can take it. Okay. It's real easy. It would really be real easy for me to say, well, you've got to defend yourself and contest that debt. Well, that could lead to a lot of frustration for some seniors because they're just not able to do that. You know, it's just too complicated for them to contest the debt based on fraud. Although they could, but if they're not able to do that, they don't need to do it. Okay, because no one can take their Social Security, no one can take their pension, their income's protected, so their assets are as well, as we talk about. Okay, so this person contacts us from Georgia. Says we need to talk to someone about signing up for your services. We have reached the point where we can no longer keep up with the payments on our credit cards and our RV. Um, we talk to a lot of seniors that have RVs. They, for whatever reason, they can't afford it any longer. Maybe one of the spouses has gotten sick and so they can't travel, um, or they can't drive it, or it's mechanically, there's a problem with it and they can't get it fixed, or they simply can't afford it anymore. They had this dream of having an RV and maybe it lasted for a while, but now, the RV loan is usually 15 years, could be 20 years sometimes. And that maybe they're just too old. You can let this RV go back, okay? And that's what we tell people. If you don't have an RV you can't afford. Now, obviously, if the RV is worth more than what you owe, you could sell it and pocket the difference. But normally, people are upside down in the RV. They owe more than what it's worth. And if you stop making the payment, eventually they're going to repossess it. Now, how do you do that? How do you let an RV go back? Well, you don't let the lender know that you're not going to keep the RV until they call you when you're behind on the payment. If you try to call them when you're current, you're going to frustrate them because you're current. The person you talk to doesn't know how to deal with it. But if you're behind on a payment or two and they're calling you about a missed payment and then you tell them you can't afford it, that person that you talk to will know what to do. And they'll eventually repossess the RV. They'll put it on the market. They'll sell it, often by auction. And like I said, usually for less than what you owe. And then eventually you're going to get a letter in the mail telling you what's the difference that you owe. It's called a deficiency notice. And if you're a member of Helps, you get us a copy of that letter. We're going to send a cease and desist letter out to that lender, letting them know that you can't afford to pay it, you're not going to pay it. Okay? So that's how RVs work. sometimes a lender for an RV, it takes a while before they repossess it. Sometimes longer than you would expect. I remember sometime back, uh, a lender called me about an RV, and we had let them know 2 years earlier that they were going to surrender the RV, but now they wanted 2 years later. They wanted to know where the RV was, and I explained to them, well, this is the information that we provided you 2 years ago where it was. I don't know where it is now. And they called back and they said, well, this is there. And I said, well, I don't know. That's where the client left it. Sometimes lenders are slow in repossessing RVs, just so you know. Um, Eric, I'm going to get an attorney on the Discover matter. I need to release your name off of Discover? Only thanks. Yeah, we would probably need, you know, if, if it's not a lawsuit, yeah, we send them a letter. You let us know, we'll send them a letter saying we're no longer representing you in the matter and that you can have your own attorney on that. Okay? If that's what you want to do. Person contacts us from Indiana. They have $8,500 in credit card debt and $5,500 in a federal student loan. My question, I've been medically diagnosed with congenital heart failure and some other things. Will I qualify for permanent disability? Well, I don't know. That's a doctor's decision, but let's assume you are. Well, first off, you could have the student loans um, discharged if you're permanently disabled. You could do that. But even if you aren't permanently disabled, um, student loans, the Department of Education isn't actively collecting student loans. They're not. They're not trying to take money out of person's Social Security. Previously, uh, they've been able to offset 15% of Social Security for a past due student loan. Now, they haven't really actively done that since 2018. And they were going to start it up again last May, but then after 30 days, the Department of Education announced they weren't going to do that. So if you've got a student loan, I mean, you can make payments on it if you want, but if you don't do anything, they're not going to do anything to try to collect. And normally a government insured student loan wouldn't sue you. They would just, but the only thing they would do is say they're going to offset 15% of your student loan of your Social Security, 15%. But like I said, they're not even doing that now. And then if you've got 8,500 in credit card debt, you're going to owe that whether you're disabled or not. Uh, I mean, they could sue you, they could try to collect on it. The fact that you're disabled isn't going to take away the fact that you owe that money, but you're probably not going to need to worry about it because you're going to be getting disability or some type of Social Security or some type of protected income. So you don't need to worry about the credit card debt. And then you don't need to worry about the student loan because they're not going to offset anything out of your Social Security. So you're going to be fine. Okay. Okay. Person contacts us from Illinois and they say I got over my head on credit card debt. It takes almost all of my Social Security check to pay credit cards. I need assistance from helps. Well, okay, that's what we're here for. Yeah, if that's you, if if for whatever reason, it could be a lot of different reasons, your credit card debt is just racked up there and you can't afford to pay it anymore and you're getting Social Security, you can stop paying it. Okay. If you're wrapped up with a a debt management or debt settlement company, stop paying it. When if you enrolled with them, did they tell you that your income was protected? You didn't need their services? The answer is most likely no. They never told you that. If they would have told you that, you wouldn't have enrolled with them. They wouldn't be making money on you. So even the profit and nonprofit ones typically, with rare exceptions, don't tell seniors the fact that their income is protected. Said they enroll them in their services, having them make payments. And sometimes the payments are puts a senior in utter poverty, and the senior doesn't realize that they don't need to make those payments. And if that's you, you can stop making the payment. Now, let's say you made an agreement with a creditor. Does that mean you can renege on the agreement and stop making the payment? Absolutely, yes. Yeah, you can stop making the payment. And if you don't want to be hounded by creditors, look at our website, call us, we'll go over your situation. If you decide enrolling helps, you're going to give us the creditors you owe money to. We're going to send out a cease and desist letter. They're going to leave you alone. If you get another letter from a new debt collector down the road, you're going to get that to us. We're going to send them a letter. They're going to leave you alone. So we're going to represent you literally ongoing. So you always have an attorney, always have someone to talk to if you have a question. We don't want you to worry about this. This person contacts us. He says, I'm looking to assist my son who is 25 and just got diagnosed with stage 4 cancer. He's planning to complete his degree this May. It would be helpful to understand how to address student loan debt. Well, if he's got cancer and he's disabled and he owes student loans, uh, he can have the student loans waived. But like I said, explained just a few minutes ago, even if he doesn't pay the student loans, no one's going to take money out of his Social Security. You can call and talk to us. He's going to be fine. Excuse me. This person contacts us from Georgia. Says, I'm going to be 78 this coming July. Had some serious medical issues. Been in the hospital. I've been forced to run up my credit cards for groceries and other needs, like medicine and doctor's visits. Now the hospital is sending me bills. Even though I'm Medigap insurance, I qualify for additional medical help. And his trouble started when he was trying to help one of his kids. He had to pay over $7,000 to help him get an apartment. And the kid took advantage of him and took money from him. He's paid off his home and he has some equity in the home. He doesn't want to move at his age. He's 78. He has 2 credit cards. One has been sued him. He's been trying to pay the other ones, but he just can't afford to do it. What are my options? I'm very worried that they will attach a debt to my home equity. Is that possible? Yeah, it is, but they're not going to take your home. We'll go over this. You read the rest of this. Hmm. So, okay, he's got a free and clear home. It looks like he's from Georgia. Every state has a homestead exemption uh, to one degree or another. Okay, some states like Texas and California and Texas and Florida and some of the Midwest states have unlimited homestead exemptions. Doesn't matter what the home is worth. If it's under a certain size, then it's completely protected. Georgia isn't one of those states. But even if you live in a state where you have equity in a home over and above the homestead exemption for your state, it's not the practice of consumer judgment creditors if they were to sue you and get a judgment to take your home. Now, theoretically, it's possible for them to try to do that, but they don't do it for a lot of reasons. And if they were, there's ways that it could be stopped. Okay. Um, so this guy, he ends his email to us. He says, "Sadness and debt are taking my sleep and life away from me. Right when I thought I was handling it okay. Please advise." We're going to call this guy and we're going to help him out. We're going to tell him what you know, why he doesn't need to worry and what can be done. Okay. Now, a lot of these problems were caused when he tried to help his family out, his kids out. Sometimes I think I talked about a few days ago, I talked about a client, a widow, who was helping her grandson with the car payment. She was making the car payment and even paying the car insurance for her grandson. He wasn't paying anything. And she was complaining and stuff. And I told her, I said, "You got to stop doing that." And I think she was probably worried about what to tell her grandson. And I told her, I said, "Tell your grandson that your attorney told you that you had to stop it. It's not your decision. You wanted to pay it, but your attorney instructed you that you had to stop making that payment. You had no obligation to keep paying your grandson's for his car that he was driving for his car insurance. He's got to deal with it. Okay. And you can blame it on me." And I don't know hopefully that's what she did. I've said that more than once in my career. Said, just blame it on your attorney. Your attorney says that you cannot do it anymore. So we'll be able to help this people. So no matter how complicated your situation is, some people call and they'll say, "I've got a really unusual situation, Mr. Olsen. It's really complicated." And I guarantee you, it's nothing that we haven't seen before. Okay. And the other attorneys here, it helps. I mean, we have been dealing with these problems for decades, and we have tens of thousands of clients, and we have helped tens of thousands of people in the past. So there's very rare is there in a situation that comes up that we haven't seen before. Now there may be a little twist on this situation, but that's okay. We'll know what to do and how to tell you. We'll talk to you about, give you information on your options and what can be done. Uh, and one of the most important things uh, is that we're going to tell you not to worry. Okay, let me see. Is there a question I missed here? Good. If I die, this is from Teresa Beck, one of the chat features. If I die, will my daughter be responsible for my unpaid debt? No. Your family isn't responsible for your unpaid debt. Now, if you die and you have an estate, which means you have assets, uh, the debt may need to be paid before your heirs get anything. But like I talked to someone yesterday, um, their only asset they had was some money they had set aside for their burial, and they were worried that if they died, then a creditor was going to be able to take that money and they wouldn't have available for burial. And they said, no, that's not the case. If you have money in your estate, it goes first for to get you in the ground, take care of your burial, and then medical bills, and then other debt, and after that, if there's anything available for your family. I would say the vast majority of helps clients, they don't have an estate. Okay. Their asset consists of maybe they got some furniture at home, a monthly social security check. And when they pass away, there's really not an estate. The furniture isn't worth enough money to go through probate or anything like that. Just distribute it or give it to Goodwill or give it to the family members. It's not worth that much. It's not worth it. Um, but you can always call and talk to us. We're glad to go over this with you. Okay, this person contacts us. A California client of Helps. There was a lawsuit and a judgment, and apparently they weren't served with the paperwork, but they found out about the judgment. I think I remember talking to this person. They owed the money, and the wife only was sued. I explained, well, you could contest the lawsuit if you wanted to by going to the court and explaining and showing how you weren't served with the summons. But you very well could have been served, didn't realize it, or you forgot about how it got served. Um, but she does owe the debt. And I said, even if you had it tossed aside, the fact that they got a judgment against you, all they have to, because of the service was done incorrectly, they could just serve you again and start over the process, and then eventually they're going to get a judgment. But it doesn't matter because they can't collect from your wife. She's judgment proof. He got 3,000 in Social Security, and she got 1,000 in Social Security. Um, they have a joint savings account with her name on it, but the money was from his money that he got from a settlement. And I told him, I said, well, your wife's been sued. You need to get that her name off that money. Just close that savings account out, get that money in your name only. It's your money. Your wife doesn't. You don't want to have your wife's name on that account because if they garnish that bank, you could hold up that money. It could be a headache for you. Okay. So told that get his money out of there, put it in his name only. So after all, it was only his money from his settlement that he received. Now they also had a joint bank account. And now he got 3 and she got 1 from Social Security. That's 4,000. And so I said, your joint checking account, 4,000. You get 4,000 a month, right? And he said, yeah. Do you, twice that amount is 8,000. Do you ever have more than 8,000 in that account? He said, no. And then you say, well, you can leave that account. That's a joint account with you and your wife. Say if they got a judgment and they tried to garnish that account, the bank will examine where the money came from. They can see that 4,000 came from federal sources, 3 to you, 1 to your wife, 3,000 Social Security for you, 1,000 Social Security for her. It's 4,000 times 2 is 8,000. And again, I reminded him, I said, you can contest the service, but it may not be worth it. I explained to him, I said that the process server, private process servers, they get paid a fee when they serve a summons, and they have to file a form, kind of an affidavit with the court showing how they served the summons. So in the court records, there's going to be something signed by the person who served it on who and where and how he served it. Now, in my almost 5 decades of practice, I have talked to hundreds and hundreds of people that have told me, well, I wasn't served with that summons. They didn't serve me right. Okay. And then I tell them what they can do. I said, you can go to the county and go in the court records on your file, and there'll be an affidavit explaining how you were served. It could be that they served someone at your home, okay, that was living at your address. You know, I can't recall ever someone coming back to me and saying, well, Eric, I checked the court records and I was served improperly. Now, may have happened. I just don't remember it. But when you check the court records, you think you haven't been served. All of a sudden, you find, well, I guess maybe that did happen. Maybe my grandson was in the house that day. He's 16 years old. I don't know what happened to the paperwork. Maybe my wife got it and she forgot to tell me about it. Maybe it got thrown in the trash. But anyway, you could contest it if you want. But once again, if your only income is Social Security or pension disability, you don't have to contest the lawsuit or the service of the summons. Now, sometimes I read articles and they say, well, you've got to do that. You can always contest it. Well, that's easy for someone to say, but if you're a senior and you don't know what you're doing, that can be difficult. And that's why I'm telling you that if you're judgment proof and you owe the money anyway, you don't have to contest it if you don't want to. You can, you don't have to. Make sense? Okay. Person contacts us from the great state of Oregon. My problem is with the federal IRS. They garnished 100% of my Social Security in both January and February this year for back taxes due on a non-authorized I liquidated 2 years ago to pay bills. Social Security is my only source of income. She and I look forward to speaking with you. I kind of doubt that that's the case. IRS normally doesn't garnish 100% of Social Security. Now, maybe if the Social Security went into the bank account and then they garnish the bank account, yeah, that possibly that could have happened. But if the IRS is going to take money from your Social Security, what they do is they send a notice of intent to offset 15% of your Social Security after 60 days. So yeah, if the money went into your bank account, they could garnish your bank account, take money out. And if it happens to be Social Security in there, they would take all of that, anything that's in the bank account. But this person's Social Security is his only source of income. We'd be telling them that they could qualify and apply to the IRS to get on what's called currently not collectible status, CNC status. So if you're a single person with income about $2,500 or less, or $3,500 or less, if you're a couple, you should easily be able to qualify to get on currently not collectible status with the IRS. We have an email that explains how that's done. You can call us. We can send you that email. Okay. He said, this person writes us, they say, my summons says that if I don't appear, I will have a judgment by default, and I'm 69 years old. Okay, great. Well, what's a summons? Okay, when you get sued, there's two parts. There's a summons and complaint. A summons is a notice from the court saying you've been sued and tells you what you need to do if you're going to defend the lawsuit. And then the complaint details who you owe money to, for what reason, how much money. Okay, so the summons part of the summons and complaint, um, and it may have a different name. In some states, it has a different name. Like in Virginia, they call it a warrant and debt. But most states, it's like a summons and complaint. And it says, yeah, it tells you that you have to file an answer within so many days. It could be 20 days, could be 30 days. It depends on the state and the type of court. Small claims is usually quicker than regular court. And then it also explains if you don't do anything, they're going to get a default judgment. But if you owe the debt and your income's protected, so what? They can't do anything to you. So if you're one of our clients and you get a lawsuit, we're going to ask you to get us a copy of the lawsuit, usually the first 3 or 4 pages. We're going to send a letter to the attorney who sued you. We're going to let them know that your income's protected and you can't afford to pay the debt. You're not going to pay the debt. We're going to call you on the phone, explain why you don't need to worry. We're going to send you emails explaining why you don't need to go to court, why your bank account is protected, why your assets are protected. Okay, this person contacts us and they say, Okay. Oh boy. I was told by my bank that if a judge has a judgment against me, they have to let them take my Social Security money. So I'm paying so much a month for 2 years. I was told, don't worry about it, ignore it. That was not true. So I have another letter from another company that bought the credit card account and so forth. What is the truth? Well, the person at the bank doesn't know what they're talking about. Now, some people answer questions when they don't know the answer, or they think they know the answer, or they answer the question what they think is the answer, whatever. So when the person at the bank told them that they have a judge, they'd have to take money from the Social Security, not true. Now, I've explained before clearly that if someone gets a judgment and they garnish your bank account, what happens is there's a department of the bank that examines where the money came from that was deposited in your bank account. If it came from a federal source, they times that times two and protect that amount of money. Now, your bank manager doesn't know that rule. And definitely the clerk behind the counter doesn't know that rule. Okay, because they don't deal with garnishments. That's not what they do. So he believed this person at the bank, and so he worked out an agreement to keep making payments. And then someone told him, maybe it was he listened to us, that he didn't need to make those payments, that it wasn't true what the bank had told him. And he says he's got another letter from another company that bought the account and so on. What is the truth? Well, the truth is what I've told you. Your income's protected, can't be taken. And call and talk to us if you want. Okay? Um, they can't touch your Social Security, and when it's deposited in your bank account, it's protected automatically, even if there's other monies in there, twice the amount you get each month. I've I've said before that maybe 1 out of 1,000 attorneys know that rule. Maybe a few more now, but it's been in effect since 2012. It took a long time for people to get on board. The banks got on board pretty quick. Credit unions got on board a lot longer, but a lot of attorneys, they don't practice in this area, so they don't know that rule. They're not involved in collection. They don't know this stuff. Okay. I remember talking to my former partners in my bankruptcy law firm, which is quite big and a lot of attorneys. And I asked those guys at a meeting one time, I said, after I'd left the firm and was doing helps, and I asked them this question about protected income. None of them knew this. None of them knew the fact that twice the amount of Social Security deposited in your account or federal funds was automatically protected by the bank from garnishment. And they're the ones who are active in this area of the law, but they didn't know it. So that's the truth. Okay, this person contacts us from, I think it's Missouri. Hello, I've seen you on YouTube. I was impressed on what I saw. Okay, great. Okay, he says, I hired a debt company to pay my debt down. I was getting nowhere fast, and I couldn't afford the payment anymore. I'm 72, disabled on Social Security, and I can hardly make it, so I fired them. Good for you. And I would say, when you hired them, did they tell you your income was protected? The answer is no. Now he says, now I have debt companies, creditors, debt collectors coming after me. They say they can take my home, cars. I know a little about the law and know they can't, but I need help from a company like yours. If I can afford you, I would really appreciate the help. Thank you for reading this and hope to hear from you soon. From all the penalties and fees, I think around 20,000, and I've tried to offer settlements to them. A couple tried to work with me, and the rest is a joke. I can only afford so much. Thank you for your time. Well, right. He doesn't need to worry. They're not going to take his cars home. Can he afford us? Yeah. The most a person would pay to enroll in health would be $40 for 24 months, then $20 for 24 months, then free thereafter. Or $30 for 24 months, $15 for 24 months, free thereafter. Or $20 for 24 months, $10 for 24 months, free thereafter. We make it work for people. Okay. And some of our clients get our help for free, like I talked about earlier today. Okay. Says my name is. I have a certain disease and have been disabled since 2021. I got on Social Security disability in 2025. I was married for 15 years and divorced in 2025. I had a 850 credit score when I married my husband. He used my credit cards as his own to buy rental houses and was getting credit cards in my name behind my back. Now that we are divorced, they are coming after me. I did not know he was doing this. So far from my credit report, there's about 80,000 in credit card debt. Two so far have come after me, which Discover for 32,000 and American Express for 11,000. I have a lawyer working on those, but I can't afford to keep paying him. My brother is on Social Security disability as well, and he uses you. It helps to help him. And this person's on Social Security disability. Um, Again, I'm an innocent into this credit card debt. Why my ex-husband did this to me? He abused me in different ways. Uh, I'm 58 years old. Can you help me? I am told from my brother that Social Security disability is federally protected from creditors. Is this correct? Yes, it is correct. Let me know if you can. Yeah. Um, it may be difficult to fight the debt, saying that your husband incurred the debt. Okay. And you got a lot of them, 85,000 worth of creditors. You don't need to necessarily do that because they can't do anything to you. Your only income is Social Security disability. Like I explained, if they get a judgment against you and they sue you, just keep the balance in your bank account less than twice the amount of what you get in Social Security disability each month. It's protected. Now, theoretically, if you wanted to, you could file bankruptcy and wipe out the debt, but uh, probably don't need to file bankruptcy. Couldn't afford to file bankruptcy, but they can't collect from you. And if you enroll in helps, you're going to give us the creditors you owe money to. We're going to send them a cease and desist letter, and they're going to leave you alone. So the bottom line is you don't have to worry about this situation. You're going to be okay. Now, if you're listening to me and some of this stuff sounds familiar to you or related to you, don't hesitate to call us, 855-435-7787. So what we do is we help people, okay? Please help me. I'm 68 years old and being sued by debt collectors. I have been summoned by Citibank to show up in court on March 23rd. I'm worried they eventually could put a lien on my vehicle. I am on Social Security struggling making credit card debt and loans. Shouldn't have a problem with your car. It is possible in some jurisdictions for a judgment to become a lien on a vehicle, but in my practice, I've never seen that as an issue that's caused someone's problem for a lot of different reasons. Um, Person contacts us from Texas. I'm on Social Security disability. It says county judge found an order to freeze my bank account, which is not federally protected. The bank froze my account, which is illegal. It's only about 500 in there, not 2 months worth of my benefits. I was put on disability and could no longer pay my debts, so credit card bills over the last. So the account that's automatically protected from garnishment is the account into which your Social Security is deposited. Now, if you have another bank account that maybe Social Security went into, but it wasn't the one that it wasn't automatically deposited into, then that account could be vulnerable to garnishment. Okay, but but you could file a challenge to garnishment or claim exemption and have the money released because you could show the court that the money came from a federal source, from your Social Security. Plus, they live in Texas, and there's other exemptions they could apply to get the money released. Person contacts us. They say, "I'm 74 years old, single woman. I'm making credit card payments faithfully. I have a car payment. Also, my home is paid off, but at the end of the month, I barely have enough money to buy groceries. I wanted to know if I stop making my credit cards, can they come after my home? I need my car for going to doctor's appointments and just getting all around. Will I be able to keep the car? Yeah, keep making the pay. Assume that you can make the car payment. If you don't pay the credit cards anymore, you're going to have some extra money. Are they going to take your home? No. Uh, Depending on the state where you live, the home could be protected from a lien automatically, but even if it isn't, it's not the practice of consumer judgment creditors to go after people's homes for a lot of different reasons. And we're happy to talk to you and go over that with you. So this person says, I'm 85 years old. I may have read this before, I can't remember, but it's pretty common. And I've lost my source of income due to factors beyond my control. I would like to avoid Chapter 7 bankruptcy as possible. Any advice would be, yeah, an 85-year-old person with their income is not going to need to file bankruptcy. I mean, I guess I could envision a case where they could. It might make sense, but it'd be difficult to imagine a case where they need to file bankruptcy. Uh, no one can take their income. They're going to be fine. We'll be glad to talk to them and give them some information. Okay, I think I'm done. It's been a good session today. Thanks for participating. I think, let's see if there's some more questions I didn't deal with. Can a person younger than retirement age but on Social Security use your services to defend? Yes, absolutely. Doesn't matter what your age is. As long as you're getting protected income, we represent you. We have a lot of people in their 30s, 40s, 50s that are not that are getting Social Security disability. How is it that these debt relief companies get the credit card amounts reduced to 40 to 50% with a fee? Uh, and an individual cannot negotiate lower credit payments. Well, they can normally. An individual could usually do the same thing that a debt negotiator can. I have not filed bankruptcy. Why do I receive numerous calls from debt consolidation companies saying I qualify for thousands of dollars? They're trying to get your business. I'm sorry I missed some of these questions earlier. Uh, So call us if you have any questions that I haven't addressed. Okay, if I haven't addressed it, you can always put questions in the comments and I'll try to look at them there later and answer your questions, or call us toll free. Okay, God bless, and I will talk. Now, tomorrow, you're going to have a special treat. Kaisa Jansen, attorney from Helps, is going to do it tomorrow. She's really smart and she got good answers, good questions. So be sure and tune in tomorrow and listen to Kaisa. Okay. Um, okay. Have a great day. Bye.